That was the punishment decided on last year for former Minneapolis police officer Derek Chauvin for the May 2020 killing of George Floyd. Jurors determined he knelt on Floyd's neck until he died. Attorney Michelle Trigger with me live now to break down Chauvin's new request for his case to be reviewed again. Welcome back to Fox 40 News at 11.
Thank you for having me.
Definitely. First, let's remind everybody, in this killing of George Floyd, Derek Chauvin was found guilty of second-degree murder, third-degree murder, and second-degree manslaughter, which did confuse a lot of people because there were 3 different guilties for one death.
That's correct. The theories of the 3 men were distinct. In other words, some of them had more culpability. Specifically, of course, we would have had a situation where Derek Chauvin at some point was engaging in conduct that would have satisfied all 3, but ultimately he would have been mostly guilty of first degree. But it's very, very common for prosecutors to charge multiple theories and to be able to prove those as well.
In his filing in the Minneapolis Court of Appeal, Chauvin is asking for his conviction to be reversed outright, or for new sentencing, or for reversal and remand for a new trial in a new venue. His lawyer, William Mormon, says that a new venue is needed because this trial should not have been held in Hennepin County, where George Floyd was killed, where jurors were intimidated by protesters around the courthouse and prejudiced by pretrial publicity that demonized Chauvin and glorified Floyd. Is that a fair characterization, demonized?
I don't believe it's a fair characterization. I don't believe that most people would agree with that. The truth is not demonizing someone, but it is very common for people to seek a change of venue because it is considered potentially prejudicial to have someone prosecuted in a venue where the local jury pool is considered tainted. We often see this with high-profile cases where there's been so much coverage locally and the jurors are so invested personally, their community is so invested that you can't get the type of neutrality that you would hope to get from a jury pool. So many people saw this coming. Quite frankly, it can be a little bit of a desperate ground when you have nothing else. But no, it's not demonizing someone. He did the conduct, and I think most people would agree that it was a fair trial.
Given that this killing inspired protest worldwide, does the new venue argument really have any weight? Because where can you go at this point where people haven't seen this video or don't know this case? Could a valid argument actually also be made by the state that all that publicity gave time for people who might have ended up in the jury pool to equally see and maybe support why Chauvin behaved the way he did versus being outraged by it?
I do think that it's generally a fair argument to say, look, this is not a fair situation. People have had an opportunity to independently investigate the situation, potentially before they even realized they were a juror, but certainly after, even when instructed not to. But you make an excellent point. This is nationwide coverage. I'm not sure you can go anywhere in this country where someone hasn't seen the video, heard of the video, been inflamed by the video. I think there might be a very small demographic that would agree with Chauvin, but those people were probably going to be weeded out, whether it's that jury pool or any other jury pool. So they're going to take great efforts to change the venue, but ultimately, I'm not sure they're going to find a venue anywhere where people are not very familiar with this case.
Alrighty. Attorney William Mormon claims Judge Peter Cahill acted improperly, not applying sentencing guidelines correctly, and that he should not have included abuse of a position of authority as an aggravating sentencing factor. To the layperson, it would seem misbehavior of a police officer, a person in a position of authority in our society, is at the very foundation of this case, of this killing. So why wouldn't that be a reference in sentencing?
So generally, when you do sentencing, what most people don't realize is that there's not a one-size-fits-all sentence. Generally, every type of crime comes with multiple options for the judge to choose from. Here in California, we refer to it as a triad. And generally, they're going to be guided by mitigating or aggravating circumstances. So you start with the crime, and then you determine, was it more aggravating than other crimes similar? Or was it less aggravating? And so in this situation, the argument has been he wasn't actually abusing a position of authority. I agree, to the layperson, that's laughable. To many attorneys, it's laughable because ultimately there's no more important position when you're carrying out justice and potentially in this situation committing a crime while doing so than a police officer. But ultimately, I will say that that is an aggravating circumstance that's generally reserved when there is a position of authority between two specific people. So it's a little bit of a stretch, but it's not generally used as it applies to a police officer and an arrestee. So that's kind of what he's getting at. I don't think it's going to be a successful argument, though.
Alrighty. Now, this is a case that might never have made national headlines, international headlines, or inspired calls for racial and social justice worldwide without the video shot by then teenager Darnella Frazier. So even if Derek Chauvin is granted a conviction reversal or a sentence reversal, how does the defense team get around what can be plainly seen on this video?
I mean, as a defense attorney, I've seen some pretty hopeless cases. I would not want to be the defense attorney on this case. When you have a crime that is literally on video, a jury can see it with their own eyes. It's borderline indefensible. And so I sympathize with the defense attorneys in the sense that there's not much that can be done. I think they're going to have to target the elements of the crime such that they perhaps argue that this was not, he didn't have maybe the proper mens rea, which means he didn't have the proper mindset to actually convict him of some of these more serious charges. But as far as the conduct itself, it's a very startling video, as we know. Thankfully, we're living in the day and age where crimes are being caught on video. That was not always the case. And that it was actually, for lack of better words, a good video. We're able to get a good vantage point. This is not grainy surveillance. This was a heartbreaking video because it was so vivid.
All righty, thank you so much. And we know the state prosecutor there in Minnesota has about 40 days to respond to this appeal request. Thank you, Michelle Trigger with Trigger Law. We appreciate your insight.
Thank you.